Sorry, Judge, I would like to say that the BVR is kind of, it conflicts with itself. It says there's a tamper, then it says there's alcohol detected, but alcohol cannot be confirmed because of the way it was tampered with. So I don't know if we have further information to.
We never do. We never do. And the problem is that what happens is people try to put stuff. What is the one thing I asked you? I'm sorry, I ordered you not to do?
Not to drink alcohol, and I haven't. I'm 51 days sober today, and I live in a sober living facility, so I get breathalyzed and drug tested at least 3 to 4 times a week. Anytime that I leave and I come back, I went to an inpatient program, and I completed that. I have my certificate right here.
Show me that you have a breath test on 10/26 at 9 in the morning, because if what you're telling me is true, you should have a breath test at around that time, and let's see.
Yeah, I would have to get with the coordinators of the staff at the place that I live in. I'm sure they have it all logged.
You're supposed to have that here today, though. Today is the day that's set for your bond violation hearing.
Well, Judge, we didn't go over all that because I was hoping to get more detailed info. It sounds like there's a tamper, but they're not confirming alcohol. They're not confirming alcohol.
Because of the tamper. What we have normally is someone does something to the device to the integrity of the device to bypass alcohol detection. They could put a sock in between. They could put a piece of paper in between. They could kind of move it so the skin is not touching the device. There could be a whole myriad of things of how the actual tamper takes place. All we know is that we have a tamper and we have a confirmation. Well, we have alcohol detected. We can't confirm because of the tamper. The nature of the tamper prevents confirmation of alcohol.
Judge, sometimes these devices, they're not perfect, Judge. They can't ever tell me what happened.
So if there's ever a problem with the device, it is your responsibility to go to the place and get it fixed.
Yes, sir, and I did. Whenever I went to Sentinel, I asked the guy who put it on me and was downloading my data, I asked him to tighten it because I felt as if it was too loose. And he did tighten it, and he said he wrote down on his notes that he tightened it for me. I've been sober for 51 days, and
how do I know that?
I have my certificate that I went to an inpatient program, and I'm living currently in a sober facility. And I'm doing that for myself because I do have an alcohol problem, and I'm 51 days sober as of today.
If you're telling me that you have all that information, that they test you frequently, then you should be able to have testing at that time. And if you can show me that you have a breath test at that time that shows that you're not have alcohol on board, then I'll throw the piece of paper away.
And we do this, Judge. Would you allow us to get time to get those documents for you? We weren't prepared to present that to you today. I was looking to get more info on the actual report.
It's supposed to happen today. You guys are supposed to come in between the time we let you know about the violation, to do your diligence, to figure out what the violation is, how it occurred, and how to remedy that.
Judge, that diligence isn't on us, Judge. They're the ones alleging this. They need to provide.
They're not alleging anything. I am, because you have alleged violations here. It is your duty to show us why
We could bring these people that are alleging this tamper, we could bring them and have them testify regarding what they know and what they do not know. Instead of just assuming that they are correct, we could have a hearing.
No one's assuming anything. I'm telling you, if you have something that contradicts this, show it. That's what I'm telling you.
I also did my due diligence of making them tighten it. I told them to tighten it myself.
I understand.
And he did say he wrote a note about that. Because I was
still have
that this would happen.
Mr. Barahona, I still have alcohol detected, regardless of whether it's tightened or not. The tightening is not the issue. The issue is that there's a tamper and that we have alcohol detected.
I have not consumed any alcohol.
So show me. I'm telling you how to do it. Reach out to them now, see what you can get. See what evidence is out there to show me, I'll put you guys to the side, reach out to them, see what they have. If you're telling me that they've tested you as frequently as they are, they should have something.
Yeah, talk to my client, see how quickly we could get that info.
No rush. No rush. Take your time, see what you can find. Okay, Ricardo,
Judge, we're approaching on Mr. Ramon Barahona.
do you need until Monday?
No, because here's what's going on. So I was kind of unsure about what he was talking about. And after talking to him, we don't have, we're not going to have a breath result for him because they haven't been testing him, is what it sounds like. And so we got two options, Judge. The way I see it is two options. One, you could revoke them. You could say, well, let me talk about what the specific is on the revocation. Alcohol was detected during tamper. However, alcohol cannot be confirmed as consumption because of nature of tamper. So I would argue, I'm not conceding that something happened. I'm conceding there might be a tamper. I'm not.
Come up, Mr. Barahona.
If you're going to revoke him, I would ask for a full-blown hearing. If this is one of those situations where he's just admonished and, hey, this is your one shot, then he understands that. I don't know how you want to proceed with this, Judge. I'm not conceding that he drank alcohol. He's been in this location, in this center core location since September 17th. He did inpatient. October 18th, he graduated. Then he moved over to Center Court's sober living facility on October 18th. He's been in there since then. We have proof of that. He's been attending 6 meetings per week, 1 counseling session per week, 1 group counseling session per week, 3 AA meetings. He's there. He's doing something. I would ask that we just admonish them.
Machines don't test positive or shites and giggles, man. They don't. There has to be something there to make it test positive.
Well, Judge, on that aspect.
It doesn't spontaneously test positive for alcohol.
Well,
For you to say that it does, it's just disingenuous and not true. There has to be something to set the machine off. It doesn't spontaneously test positive.
I have not consumed alcohol for 51 days as of today.
The machine is telling me differently, Mr. Barahona. You know how many people tell me the same thing with the exact same facts that you have? You know how many times I hear it a day?
I would assume a lot.
If I had one strand of hair every time I heard it, oof, I would look good.
Judge, I did talk to him. This wouldn't be much of a solution since this is from 1026, but we could test him today. I don't know how long something stays in the system, if that's the allegation, but he's willing to test today.
That's going to be no bearing on me.
Right.
I mean, this is 2 weeks ago, you know?
I get it.
I'm just now, unfortunately, they just give us the results now, but
And regarding the actual, I've gotten reports before that says what this device is reading. There are reports out there that they can provide.
if they don't tamper, then yes, you will get a true and accurate reading. And that's what the problem is that there is something that was tampered with, and Mr. Barahona knows. He's the only one that knows what happened on that date. We don't, because we weren't there. We don't know what happened. So I'm sorry, Mr. Barahona, but I told you one thing. I told you one thing only, you know?
I would like to state the fact one more time that I did tell the people at Sentinel to tighten it because I didn't want something like this to happen. I don't
This
think
is
it's
not a matter of tightening. It's a matter of alcohol detection. If a device is loose, it's not going to test positive for alcohol. You understand that?
I
Just,
understand what you're-
there has to be an intervening event that has alcohol in it for it to test positive. And there's something seriously afoot because the device is telling us that someone is messing with the machine. If we not had the messing with the machine, then we would know whether there was true alcohol consumption or not. But here we have a positive and that you're messing with the machine. Okay, goes with you. You're Dwayne Leon Leroy.
Yes, sir.
So Leroy, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with reckless driving. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. On your other case, you're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On November 3rd, 2024, officers observed defendant's motor vehicle traveling at a high rate of speed, 105 miles per hour, making unsafe lane changes, cutting off several other vehicles, and driving through narrow 2-lane construction zones and on the Sam Houston Tollway. The officer was able to catch up with the defendant and initiate a traffic stop. Officer made contact with the driver and observed mild odor of alcoholic beverage, red bloodshot eyes, and a slight sway. Officer observed a brown bottle of alcoholic beverage under the passenger seat, open and half empty. SFSTs administered, HGN 4 out of 6, walk and turn 4 out of 8, 1 leg stand 3 out of 4. Defendant denied drinking anything, then claimed to have only consumed 1 beer. DICs were read and breath was refused. Blood search warrant was obtained and executed.
Are you telling me that he's going through a construction zone at 105 miles an hour?
That's what I have here, Judge, per the dams.
Any prior DWIs? Mind checking? Or any kind of other reckless driving?
I don't see anything that has to do with driving on his record.
There's a lot of construction on the toll road. If you're going that fast, probably pass through it,
But
rather
you're
quickly.
supposed to slow down at an extreme slow place when you're
I agree.
extremely slow pace when you're going through a construction zone.
I agree.
Mr. Leroy, I'm going to find that there's probable cause to go forward with the case, and I'm now taking away your privilege to drive. You're not allowed to drive at all. Do you understand?
Yes, sir.
You will be signing an affidavit with me, and I hope you take it seriously, because if not, you will be facing 6 months in jail and a $500 fine every time you drive. And I don't care what your excuse is. Mother Teresa needs a ride to church. You come down, we will have a hearing, and you're facing 6 months in jail and a $500 fine every time you drive. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, likewise, you will go to jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
These are 2 different affidavits that you're going to be signing. So if I find that you drive, and I don't care what it's for, I will have 2 contempt hearings every time you drive. You have a lawyer. It is your responsibility to stay in touch with Mr. Aigle, and he will tell you when you have to come back to court. If he comes back to me and tells me he can't get a hold of you, you pick up a new case. You violate conditions, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Okay. All right, we'll have you go.
Thanks.
Listen closely to what the judge just said. The machine is telling me differently. That's the system speaking louder than the defendant. In court, credibility is currency, and once the judge stops believing you, everything gets harder. Bond, probation, mercy. Be honest. Who do you believe here, the device or the defendant?
All right, you are Eric Matthew Mack.
Yes, sir.
Mr. Mack, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with interference to the duties of a public servant. On both of those, you're facing up to 6 months in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On October 30th, 2024, officers were patrolling an apartment complex in Harris County, Texas, that is known to have a high amount of crime. Officers are familiar with the property manager who has complained about trespassers in the past. There were multiple no trespassing, no loitering signs throughout the apartment complex. Officer observed the defendant walking around the apartment complex wearing a hoodie with the hood up and a mask covering his whole face and holding an unknown object in his pocket. Officer asked if the defendant lived in the complex, and the defendant did not answer. Officers believe that crime was afoot as defendant refused to remove his hands from his pocket. Officers attempted to Terry frisk the defendant for any weapons. The defendant refused to be patted down for weapons. Officers attempted to detain him for a criminal trespass investigation, but he refused to be placed in handcuffs. He resisted to be placed in handcuffs, and it took 4 minutes. It took 4 deputies to detain him as he kept pulling away and moving his hands away from each other. It was determined that the defendant did not reside at the apartment complex.
Mr. Mack, I'm going to find that there's probable cause to go forward with the case. How old are you, sir? What do you do for a living? Why not? Sorry?
Retiring.
I can't hear you.
Retiring.
There's so many people that are hiring, it's ridiculous.
Yeah.
Did you graduate from high school?
Yes, sir.
Okay, so what's the next move in your life? You're 21, you ain't got no job. What are you doing with your life?
Military.
That would be a great idea. Holy moly, that would be awesome. Really. That will give you structure, it'll give you discipline, and it'll get you a job. That would be a fantastic thing to do. But jobless, no prospects, no future at 21, that's not going to bode well for you. So I'll appoint your lawyer today, but it's one of the two things. Great idea if you want to go to the military. If not, you must get a job, and I'm making that a condition of your bond. Do you understand?
Yes, sir.
You cannot just smoke weed and play Xbox and do nothing all day without no regard to your future. It's not going to happen. So 2 things. I don't want you going back to this location, and I don't want you to have any weapons. Do you understand?
Yes, sir.
I will have you fill out an application. I'm going to bring you back in 2 weeks, and I want to see what you have done to get a job. If you've done nothing, it's not going to go well. Do you understand, Mr. Mack?
Yes, sir.
You got to do something with your life, because if not, you're going to be hunchless, just on the side of the road, begging for money without a prospect. That's not a good way to go through life. Do you understand?
Yes, sir.
All right, come on, Stephen, I'll give you an application. You'll sign a reset with Ramona, and then we'll have you take a seat in the jury box. Okay, sorry to keep you waiting. Good morning, sir.
How you doing, Mr. Bishop?
Shh.
So Mr. Peters is wanted out of Caddo Parish on issuing a worthless check. I'm assuming this correlates to like issuing a bad check here in Texas. And so I would be asking for a bond so he could go to Louisiana and take care of this business out there and resolve it.
So he's on felony probation for a false statement obtaining credit, picks up a DWI second, and now he's got this case.
Correct. I've told him what that DWI might do to his probation.
Mr. Fisher, ma'am.
Don't say anything about the DWI because you're on felony probation for a very serious up to 10-year probation. You picked up a new case, and now you have another case in Louisiana. I mean, really.
I had no idea about the case in Louisiana, sir. I had just went to the Army base in Killeen. I was working for Bobtail Crane, and when they escorted us into the military base, nothing popped up about a charge or anything else like that. I had no clue about this. If I would have known about this, I could have easily took care of this whatsoever.
But the problem is that stuff keeps happening. When do we say when?
Sir, like I said in the case for the DWI, I was not drunk. I was on my way to work.
Really, now's not the time to fight those cases. My only point is that it just, stuff keeps happening.
Yes, sir.
State's asking for no bond. In addition to the federal probation he's on right now, we're also seeing.
He's on federal probation too?
I'm sorry, I thought you said federal, but the 3-year probation that he was on right now from the 185th out of 2022. He also had a deferred revoked in 2010 from Montgomery County that resulted in 10 months of TDC. He also had another TDC trip for tampering on a government record in 2008. He had an evading of a motor vehicle, which is a state jail felony that was reduced to a lesser evading from the 351st in 2007. He's also had a couple theft arrests that resulted in dismissals. He's also on a DWI second here in.
How many trips you got? 2?
Sir,
How many times you been to the pen?
it was just one time, sir. It was just
You're
one
saying
time.
how many times you've been to the penitentiary, Amy?
I'm seeing at least 2 here for TDC.
No,
One in 2008 and another in 2008 from Montgomery.
no. It was only one time.
Here's the thing. if you have 2 pen trips, you're what's labeled a true habitual. Anytime you pick up a serious felony, you're looking at 25 to life. So when you're out there in the free world, you have to be extra special good, because if not, you could be looking at a minimum of 25 years to life.
Yes, sir.
No, I'm just giving you facts.
Judge, if I could argue for my client a little bit, he does have criminal history. He does have criminal history. The issue here is he's got this DWI. He's made bond on that. He's got a bond there. He is on deferred as well on the 185th. I don't show a court date there. I don't see anything happening there as of yet. The only thing he's here in front of you right now is for issuing a worthless check out of Louisiana. This is something that could easily be taken care of, possibly by paying something even from here. If not, he is willing to go to Caddo Parish and avail himself to that parish and figure that out. It's not a serious case, Judge. He does have history. He was, from what he tells me, he was unaware that this popped up. I don't know when this actual case was issued, when it was presented, when it was filed.
Is this a new case? Is this an old case?
It was issued October 31st. The offense date was September 14th.
Of this year? October 31st of this year?
The warrant was issued
I'm
this
sorry,
year.
24?
Yes, the warrant was issued this year. The offense date was September of last year.
October 31st of this year.
They issued the warrant on October of 24. But the actual alleged offense date is
September of last year.
of 23. Okay.
So less than a month, Judge. He's been in Texas.
My problem and my concern are 2 things, though, Mr. Peters. Number 1, are you a danger to the community? Number 2 is you've got a lot of theft cases, and theft cases where other people are involved. So if I set you a bond, is it someone else's money that's going to pay for you to get out? You know, you've got a false statement to obtain credit. You've got a bunch of theft cases. Now you've got another theft case out of Louisiana. So is it someone else's money that's paying for you to get out? And then when we get you out, are you still a danger to the community? You know what I mean? Perception is reality, Mr. Peters, and your record speaks for itself.
Can I say something, Mr. Fisher?
Just don't talk about the
No,
cases.
I'm not talking about the cases. We all have a past. You know what I'm saying, Mr. Fisher? Some of us been caught, some of us haven't been caught. But at the end of the day, I have changed my life and turned myself around. Since all of those things that you have talked about, I have been driving trucks. I have been doing right by the community. I have custody of my 11-year-old son, that I am being an example of what a man should be. I have done everything that I'm supposed to do, Mr. Fisher. I'm not out here causing chaos and controversy about anything out here in society. I speak at the local church.
DWI 2 days ago, a second DWI, you're on the felony deferred, and now you've got a fugitive case.
Mr. Fisher, that was, again, I was not under the influence. I had just got out for work at Bobtail Crane. That's when that transpired. I told the officer that I did not have anything to do with the drink. He said, because your eyes are red. That does not solidify me as being drunk. I was tired. I just worked 16 hours.
Don't talk about specifics.
Yeah, don't talk about
Okay.
How much is the value of the check?
It was like 511. It's under 1,000.
Judge, he hasn't made a mistake in your court. We're just asking.
But my concern, Ricardo, is where is he going to get the money to pony it up?
Well, Judge, I know you're speculating that it could be the public's money, but it could also be his money. I mean, he's been working for 5 years. He's got a CDL. He worked at Superstar Logistics for 5 years before working for Bobcat Crane. So he's been gainfully employed. It could easily be his money. I mean, there's nothing to say that it's the public's money or anything like that. He's got a history, but he's got no history with you. And so that being the case, I would ask that he be allowed to make this right. If he messes up at that point, I got nothing to say. But at this point, he hasn't messed up in your court.
Opposed to a bond? What if we set a high bond? You know, I mean, it's going to be a couple thousand. You know, it's going to be 5,000 to 10,000.
I can stop you, Judge, but our position is no bond.
You know, the problem is that you're an inherent flight risk. So if I set you a bond, you're going to have to pony up all that kind of money to get out. This is no 10% deal. You're a fugitive case, man. So when we set you a bond, you have to post it in its entirety. No 10%, no 20%, just because of everything that you have open, you are an inherent flight risk. So you got to be aware of that. So if I do set you a bond, it's going to be at least, 5,000, 7,500.
So there's no way possible that I can, if it's 100% of that bond, there's no way possible that I can do that, man. I'm trying everything in my power. Got a good job and everything else like that. I understand.
See this,
But this is just
not all bad news, because you're not wanted out of like Wyoming, Montana, Alaska, Louisiana. We have so many people here from Louisiana. We have buses coming about twice a week to pick up people, to take them back and to bring them from Louisiana. We really have, it's incredible the amount of people we have. So around 2 times a week, we have people shuffling in and out of Louisiana. What I would say is you should save your money and use that to hire a lawyer in Louisiana to fight your case. Because I'm telling you, has he waived yet?
Yes.
You'll be out of here within the next 2 to 3 days if you keep your waiver.
Judge, if I may reiterate something, we're at November 7th. I'm still confused whether this was issued the 24th or the 31st. Either way, it's less than, even if it was the 24th, we're talking less than 2 weeks that this warrant has been open. He's got no knowledge of this. All of a sudden, he's being held 14 days in custody with something that just popped up. He's been in Texas working. I don't even know when the last time he was in Louisiana. This has been less than a month that he could have had notice that this was even present. They don't call him and tell him, hey, you got a warrant out. It's completely plausible that he didn't know that this was open. It hasn't been sitting for a year. It's been sitting for less than 2 weeks.
Ricardo, the offense date was September 20 of 23, so it would have been like a year.
The offense date, but when was the warrant issued?
October of this year,
October 24th or 31st?
October 20 of 2024.
Okay, so we're at November 7th, less than 2 weeks.
Thanks.
I'm saying he had no notice that there was a warrant issued for him. He didn't know that.
Okay.
He didn't know the case was open. I don't know the last time he was in Louisiana. He hasn't been able to make this right. He's saying he didn't have notice of this. The warrant has been open.
I mean, I understand your argument, right? But it's still got to set him a bond. If he wants a bond, I'm going to set it, at a minimum of 5 to 7,500,
Okay.
and then you're going to probably have to make, I would assume, a good amount of that. That's just the nature of the beast when it comes to fugitive cases, right? But like I said, if you keep your waiver, chances are within the next 2 to 3 days, you'll be out of here regardless. You need to make the decision, but it's a matter of you're paying a ton of money to get out when you could also save that money and hire yourself a lawyer.
Judge, one last thing. So we're talking about 100%. We're talking about.
I don't know for sure. I'm just speculating. I've never been in the bonding business, so I have no idea.
That's my understanding as well, that it's going to be 100%.
He's got a laundry list of priors. He's got 2 open cases here. He's got a fugitive case out of another state. Most probably a bonding company is going to want quite a bit of jack up front because you're a flight risk. Not only that, you're on a PR bond on the DWI second that they gave you. If you get held up there, it's very possible they revoke your bond on the DWI second. And then in the position you are here, you're going to be in the exact same position over there.
That's why I'm saying, Your Honor. That's why I'm saying, Your Honor. I'm trying to get out to handle it and make it clear so that I can handle.
I know that you're trying to get out, but my job is to protect the community.
Judge Fleischer, Dave says he's in the Zoom room.
Oh, sorry, got a day coming in.
All right.
Mr. Kim.
Hi, Judge. Are we
Hey,
still
dude.
approaching on Peters?
Yeah, he's in front of us now.
Okay. I'm playing catch up, but Amy told me that you were considering a bond regarding this defendant.
Yes.
So I have strong objections to a bond being granted for this fugitive case. I don't know if Amy has already relayed, and I don't know if you're familiar, but I was actually the prosecutor that put him on the deferred in the 185th. It was a PSI, and I was the prosecutor assigned to the case. And the 185th, when Judge Wong was still on the bench, is that he put him on a deferred, but he also had jails as a condition of his probation because they were concerned with how many thefts he had, along with the anti-theft course. And the reason why that's pertinent here is because what he's wanted for is issuing worthless checks issued on October 31st, 2024. On top of that, he's violated that deferred by committing another DWI second, along with a Conroe charge. And so he has a charge in Conroe as well? Well, it's finished now, but I believe it was after the deferred. Let me go back, Judge. It was on, well, there was two. Oh, no, sorry. I was thinking of the older one. I thought there was a newer one. My mistake. It was older. But that still doesn't take away from the other arguments presented, is that it's the same type of offense, less than 3 years after he was put on the deferred, in addition to the second violation in county, which the court can see. And that was as recent as 2 days ago.
Has the court given you any kind of guidance as what they're going to do? Do you know? I mean, I don't see.
Well, I mean, I haven't heard anything from the 185th, but because this fugitive case, the warrant was issued out on October 31st, there's nothing to say that the 185th won't revoke his deferred for the violation. So on top of the DWI sec, to say nothing of the fact that there are obviously technicals because there is a positive for alcohol. So it's a combination of things that even if the court grants a bond here, if they revoke or file the prosecutors in the 185th file a motion to revoke, he's going to be without a bond there anyway.
Judge, two things. If it is 100%, we're talking about 5,000. That would be a $50,000 bond on a worthless check case out of Louisiana.
You have so many variables here that are in play at this moment, Mr. Peters, that you could literally pay $5,000 to get out now, and then they issue a felony warrant tomorrow in your probation case that would literally be throwing $5,000 down the drain. I would be very careful. I mean, I don't know how much money you have. I know I don't have that much money, but if you have just enough money to throw $5,000 away, I would be very careful because, like I'm telling you, they could any day now file a motion to revoke your probation. A felony warrant's going to issue, and then all the money that you are putting into this is just it's out the tubes. It's out the window.
Yeah, I have to at least save my job so that I can do what I need to do to fight that DWI case. Nevertheless, I'm an innocent man until proven guilty. So whatever crimes I have done in the past, I have paid my time for that. I had did that when I was a younger man. I'm no longer that younger man that I was.
Kidding? Who are you kidding? Done this when I was a younger man. It's a year and a half ago. You're on probation. Now you picked up a DWI. Now you got this. I mean, really, who are you kidding yourself? Just look. Just if you want me to set the bond, I'm going to set it at around $500 to $7,500. Okay, if you want to do it, do it. I'll give you time to consider. But I'm telling you, it's probably not one of the wisest ideas because within the next 2 to 3 days, you'll be out of here if you don't pony up that money. And it's very possible that they any day now file that motion to revoke because they're going to let the 185th know that you've picked up 2 cases from the time that you've been on probation, right? You have. You picked up a new case in Louisiana. You picked up a case here, right? While you've been on probation. That's not one of the things that you're supposed to do. So any moment, lickety spit, they're going to file a motion to revoke. And if
actually, Your Honor, if I may, if the court does set a bond, then I'm going to ask Amy. I would be in court right now, but I'm under the weather and I don't want to risk anybody else. And so if the court does intend to set a bond, then I'm going to send an email out to the 185th right now to see if they'll revoke the deferred.
Up to you.
Talk to them about where we're
You
at.
guys talk. I don't want you to make a rash decision just because you got blinders on your eye to get out. When you guys are in the driver's seat, let me know what you want to do. Don't make a decision right here. Take your time, think about it, and then let me know what you want to do.
Thank you, Judge.
All right. Mr. Gold.
Hello again, Your Honor. I got Joel Varela Villas. It
Ready?
is a deferred plea.
Come up, Mr. Varela, or Vasquez, is it? No,
Varela Villas.
Varela.
No, that's fine. I'm used to it. They always mix it up.
All right, Mr. Varela Aviles, you're charged with racing on a highway. You're facing up to up to 6 months in jail and or a $2,000 fine. You guys have worked in agreement. They're offering you 1 year deferred adjudication. That is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. But you got to understand, you give up nearly every right known to man by entering into this agreement. And if you violate this agreement, you're looking at 180 days in jail. Do you understand?
Yes, Your Honor.
To successfully complete this agreement, you must complete a thinking for a change class, a driver safety class, and you must also do a TRAS, which is an evaluation to see what other conditions you may need. If they assess further conditions, you must fulfill those conditions, whatever they may be. I don't know. No drugs, no alcohol, and 10 hours of community service. You will also undergo random urinalysis. Is this how you understand the agreement?
Yes, Your Honor.
I will make it sweeter for you. If you do everything well, I'll take you off in half the time. But that means no racing, don't test positive, and most importantly, be nice to everybody.
I don't do drinks. I don't do drugs. I don't do nothing.
Be nice to your probation officer because they have your life in their hands. They can either, give you a good time or make your life miserable. You're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense of racing on a highway?
Guilty.
I will not find you guilty. I will withhold that. Like I said, do well, we'll reward you. If you don't do well, I'm going to issue a warrant for your arrest. I will put you in jail. We're going to have a hearing to see whether you violated this probation. If you did, you're looking at 180 days.
Thank you, Your
Do you
Honor.
have any questions?
Thank you, Your Honor.
All right, good luck to you, Mr. Bell. Thank you. Okay. Hi, Jenny.
He's on his way out right now.
Okay.
How do you spell that, Jimmy? L-E-I.
Yes. I need to send it back to him. I don't believe that.
This warning right here is no joke. Losing driving privileges isn't just about transportation, it's about future contempt charges stacking up fast. One drive turns into 2 contempt hearings, which means real jail time, no excuses accepted. Ask yourself, if you were in his shoes, would you risk driving even once?
Sorry, give me. You speak English?
Yes, sir.
Mr. Leha, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement that they're offering you 25 days in jail, credit for the 11 days.
Yes, sir.
Is this what you want to do?
Yes.
You need to understand that this is going to go on your record. From now on, you're facing a minimum of 30 days in jail.
Yes.
You give up a lot of rights by entering the agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. How do you plead to the offense, sir? How do you plead to the offense? I will find you guilty. Follow the agreement. Good luck to you, Mr. Lehan. Thank you, Jillian. All right, Mr. Martinez. Yeah, Tayyum.
Good morning, Your Honor.
For you, Arnaldo Bernabe Larios Tayun.
Yes, sir.
Order in the court, please.
You were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On October 31st, 2024, officers were dispatched at 2:46 a.m. to report to the motor vehicle sitting in the intersection of a public roadway in Harris County, Texas.
Slow down just a tad.
Yes,
Please.
of course.
Order in the court.
The vehicle was sitting in the intersection
estacionado en
of a
la
public
intersección de
roadway
una carretera, una calle pública
in Harris County,
del
Texas,
condado de Harris County,
with the
Texas,
driver
con el
asleep at the
chofer ahí
wheel.
dormido en el volante.
Upon
Al perdido,
arrival,
los policías,
officers located
ellos,
defendant's motor vehicle
encontraron el
and
vehículo
observed
sobre
defendant
manos
to be the
y lo
sole
vieron que era el
occupant
único
of the
que estaba
vehicle.
en el vehículo.
Upon
Cuando
contact with the
hicieron contacto con el
defendant,
acusado,
officers
los
observed
oficiales
red
vieron
glossy
que tenía
eyes,
sus ojos brillosos,
slurred speech, and an
para
odor of
hablar, y un olor
alcoholic
de alcohol
beverage emitting from the
que venía
defendant's person,
de su persona.
along with poor
Cuando
balance.
también no se podía balancear.
The defendant
El
admitted to
acusado
drinking,
admitió de que
and
había
an
tomado,
inventory
y
of
cuando
the
hicieron
vehicle
inventario del vehículo,
yielded several
vieron
open,
que
cold to the
varios
touch beer cans,
Drinking while driving,
siendo y tomando,
most of which were mostly
cuando
empty.
la mayor parte estaban vacíos.
SFSTs
La
were conducted,
FST se hicieron
6 out of 6
6 de 6 de la
HGN,
HGN,
plus vertical gaze
también el
nystagmus,
nystagmus vertical,
and 3 out of 4 one-leg stand.
3 de 4 de pararse en una sola pierna.
The defendant
El
failed to perform the
acusado
walk and turn
no pudo
because he
hacer
failed to
caminar y
follow
voltear porque no
instructions.
siguió las instrucciones.
DICs were read but
Entonces se le
refused,
leyó,
and a
se
warrant was
negó.
signed and
Entonces se
executed.
firmó una
He
orden y
has
se
no driver's license,
hizo.
judge, and no
No tiene
prior criminal
licencia ni
history.
tampoco tiene ningún antecedentes.
I would hope that you recognize it's elementary that you're not supposed to have alcohol in the car while you are driving, Mr. Tayun.
Señor Tayun,
Do you have a Texas driver's license? Look at me,
míreme, no,
not
a usted
allowed
no
to
se le
drive.
permite conducir.
What is your immigration status? Are you a United States citizen?
¿Es ciudadano americano?
No.
No,
Are you in this country with or without permission?
without.
What happens if you go to jail?
No me voy a saber el país.
I don't know, I believe that return me to my country.
Right.
Cierto.
You will sit
Usted va
in jail
a la cárcel.
waiting for this case to be over with, and then you will be shipped off to immigration.
Lo mandan con
But you will
migración.
sit in immigration custody for about 6 to 9 months, waiting for immigration to do whatever they're going to do. And I'm going to tell you now, the incoming president is not very sympathetic
Ese no es muy
with people
simpático.
who are in immigration custody. Do you understand?
¿Entiende? Yes, sir.
I'm putting conditions on you
Una condición,
and your bond. And if you violate it in any way,
condiciones,
then you will go to jail. The reason you got out as quick as you did is because we gave you a free bond.
Pedimos
It
una-
will not happen again. You violate conditions. More importantly, if you drive, because I'm ordering you not to,
¿Acaso?
then I'm going to make your bond extremely high.
Entonces,
This is a promise that you're going to make to me today, that you're not going to drive. And I don't care what is going on in your life.
a mí no me
You
importa.
drive. I can have a contempt hearing. You will be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. So if you drive 3 times, I will have 3 contempt hearings. You are also not to consume alcohol or illegal drugs. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail.
Consumiendo la-
And let me be frank with you. If they charge you with the open container, that is a minimum of 5 days in jail. And I'm going to tell you, if you do anything more than 4 hours in custody, you will be stuck like Chuck in custody with an immigration detainer. Do you understand?
¿Entiende?
Sí, señor.
Yes, sir.
Have you come up here, swear to us that you're not going to
Va a
drive?
jurar que no va
I'm not done yet. After that, you will get to Ramona where you will sign a reset.
a firmar la
After that, you'll get with Fleischer for your bond conditions. This is the only warning that you will get from us, Mr. Tayun. So take it. If not, you will spend a lot of time with us. When you come back, please have a lawyer, sir. Now you may go. All right, Ms. Wilshire, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. I see that you're also charged with failure to comply with the duty and striking an unattended vehicle as well. You're also facing up to 6 months in jail and or a $2,000 fine on that one as well. Okay.
On October 31st of 2024, officers received a call for service regarding an intoxicated female driving a white BMW that hit several vehicles on a public roadway. Upon arrival, officer made contact with the wheel witness, who advised that the defendant hit a Subaru on the 11700 block of Idlebrook in Harris County, Texas. Officers searched the license plate on the defendant's vehicle, and it went to the registered owner's address. Upon arriving at the residence, officer observed a white BMW matching the description and noticed fresh damage on the front passenger side of the vehicle. Officer made contact with the defendant's wife, who stated the last person operating the motor vehicle was the defendant. Upon contact with the defendant, she admitted to hitting a vehicle. HGN was attempted, but the defendant was unable to follow simple directions and the officer was unable to get accurate results, and the defendant refused other SFSTs. DICs were read but refused, and a blood warrant was signed and executed. Officers made contact with the complainant, the owner of the hit motor vehicle, whose back bumper has been scratched and detached from the car as a result of the collision. No prior criminal history, judge, and eligible driver's license.
How do you know it was her that was driving?
The license plate matched the one with the,
Yeah, I understand. Do we have anyone that puts her in the car driving?
the witness, judge,
Actually sees it's her?
no, but the witness sees the license plate and gets a description of the vehicle, and when the officers searched the license plate, it went to their address.
I know it's her car, but do
Yes.
you have anyone that identifies her as a driver? Number one, they get her at the house. How do we know she's not consuming alcohol right when she gets to the house? She doesn't become DWI, or she's not drinking at the house. There's a lot of issues. Yeah.
You might give me a couple moments and we'll
Take your time.
look at that.
You want to come back a little bit later? You want like 10 minutes?
Even less, Judge. I'm just gonna check the offense report and see what I
Okay,
got.
yeah.
Live is okay. Thank you, Judge.
You've got A, you've got C, but you don't have B yet.
Yes,
you know?
judge, no, we understand.
So I have several issues with this, Michael. First off, how do you prove it was her driving? Number one. Number two, how do we know she was DWI at the time she was driving and not she gets home and she just starts getting loaded?
Yes, Judge, I have answers to both of those questions for you.
Okay.
So the defendant driving the vehicle strikes somebody on the highway. I'll connect that later on. They find the license plate because the witnesses, I give them the license plate. They run it. The registered owner of the vehicle is the defendant. They go to her house. Her wife answers the door. Her wife states the defendant's the last person that drove the vehicle. Okay. The defendant was contacted. She admits to driving the vehicle and striking somebody on the highway.
Okay.
And she admits, I'm sorry, she first admits that she was driving and drinking, but she did not admit to striking somebody on the highway. Later on, when she gets to JPC, she admits, okay, I was drinking, but I didn't strike somebody on the highway. So she has multiple inconsistent statements. First, she says, yes, I struck somebody, but I wasn't drinking. Then she goes to JPC and then she says, right before they do the blood draw, because she declines the breath test and they say, okay, we're gonna get a warrant. We're gonna get your blood anyways and know your alcohol content. She says, okay, well, I was drinking, but I didn't strike somebody on the highway. And I wasn't driving.
Okay.
But the witness identifies.
The failure, right, to the FSGI.
Well, she admits to drinking, Judge, while driving.
That in and of itself is not sufficient. You know, at the time, we don't know, does she have bloodshot eyes, slurred speech? Do we know? All we have is just one admission of drinking. That's it.
So one of the witnesses, Judge, that observed her strike the vehicle, because they did observe her in the vehicle after the strike before she left. She states in a voluntary statement, older white lady in BMW, acting crazy, rear ends a Subaru, got out of the car, slurring her speech, barefoot, stating she was
That's
trying to
different.
get home.
You give me any indication that she leads you to
Yes, Judge.
just to believe that she's intoxicated, that you have objective facts That's something else.
There's a written statement in the offense report, judge, from a witness.
Counsel, did you want to state anything?
No, one judge.
Did you want to say anything?
No, Judge, I mean, I just agree with you. I think it's hard, again, put her behind the vehicle. They say they have a witness. The witness never really ID'd her, gave her just kind of a description, but didn't really ID and say, the officer never brought her to the scene. That's the person or anything like that.
Two different admissions, though. That's how we connect that, right? And then my other concern was whether she was intoxicated, right? Because we have a disconnect there, but we have witnesses that see her in a certain way that will lead us to believe as to why. So, all right.
She's going to dispute that she admitted.
Sure.
Judge, but still,
This is just a mere probable cause hearing, right? Just to determine whether there's enough to go forward. It by no means does it mean that you're guilty, just enough to go forward. Is it enough to find you guilty beyond a reasonable doubt? Perhaps not. Perhaps, I don't know. Evidence will point to whose side is correct, because I wasn't there. Mr. Caraba wasn't there. Michael wasn't there. But evidence will lead us to believe. I mean, there should be videos, dash cam, videos of you on the night in question, and all that will tell us whose side is correct. It will take a while, but in the interim, don't consume alcohol. Don't use illegal drugs, and I'm going to test you like crazy. If I find that you're consuming alcohol or any illegal drugs, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes.
Michael, do you see any prior DWIs?
Checking now, Judge.
Do you have a valid Texas driver license, ma'am? Do you have valid liability insurance in your name? Okay. As long as you have both, you can continue to drive. But like I said, no alcohol, no illegal drugs.
She's got no criminal history, Judge, and her
Okay.
driver's license is currently eligible.
All right. So for now.
This is a critical legal moment. The court isn't saying you drank. The court is saying the device was interfered with. And in probation law, a tamper alone can be enough to sink you. Here's the harsh reality. When you're under court supervision, the burden flips. You now have to prove compliance. Question for you. Should a possible machine error still count as a violation when someone claims sobriety?
Now, you have a lawyer. Because you have a lawyer, we will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel, and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you, we will issue a warrant for your arrest. So don't pick up any new cases. Don't use. Stay in touch with counsel, and we're good. Give me questions. All right. We'll have you sign a wreath of Victoria. We'll have you get with pretrial, and then you're free to go after that.
If I may say one thing, I like your jacket.
Thank you. Take care.
Thank you.
Thank you, Judge.
Yes, sir.
You are a licensed truck driver and have a CDL. You allegedly have alcohol in the car. You are held to a higher standard because you have a CDL. In fact, your breath tests are even lower than what a normal person is because of a CDL. And now you want me to just cut you some slack? Every person that comes in here, when they have alcohol in the car, I take away their ability to drive. Actions have consequences, and I understand that this is going to cost you big, but am I supposed to feel bad? Until I truly know that you appreciate the fact that the awesome privilege it is to be able to drive. I'm sorry. Show me that you understand and that you appreciate the ability to drive, and then I'll reconsider. But I have a real problem considering even that you have a CDL, you have alcohol in the car allegedly while you're driving. No. Take a seat for me. Show me some time that he appreciates it and not this, oh, I feel better now. I'm like, no. Proactivity that he appreciates it. Come back and we can talk.
Yes, sir.
It's not a hard line, and I'm not, we're not out for blood forever. It's just, I want to know that he appreciates it. It's not going to be an issue ever again. And then,
Yes, sir.
Okay.
Thank you, Judge.
For sure.
All right, Judge.
All right. Good morning. Are you familiar with what happened? Do you know anything about this case? First off, let me say thank you for coming. I appreciate that you're here. He's charged with driving while intoxicated. He's facing up to 6 months in jail and or a $2,000 fine. We've done probable cause. I have found that probable cause exists. Do you want to hear it? Okay. Do you mind again, please?
Yes, Judge.
Thanks.
On October 21st of 2024, at about 11:23 p.m., officers conducted a traffic stop on the defendant's motor vehicle after observing it to be traveling 35 miles per hour in the center lane of a freeway in Harris County, Texas, failed to maintain a single lane of traffic upon exiting the freeway, and driving with expired registration. Upon contact, officers observed the defendant to be the driver of the vehicle. Officers observed a very strong odor of marijuana to be coming from the vehicle and saw a partially smoked marijuana joint on the center console. Officers observed the defendant to have red glossy eyes and dilated pupils. SFSTs were conducted, 0 out of 6 HGN, but officer believed the defendant to show a lack of convergence, which is indicative of cannabis usage. 5 out of 8 walk and turn, and 2 out of 4 one leg stand. DICs were read and the defendant consented to breath and blood. The breath was 0.00 and blood was drawn. The defendant does not have a driver's license.
That's what's happened. No more marijuana. I'm sending you now for a drug test. I want to know what, if anything, is in your system. You're to come right back. If you fail to go take the test, if you fail to come back, I will revoke your bond. You do not have a Texas driver license. You are not allowed to drive. I am also making that a condition of your bond. Do you understand?
Sir.
You are 17 years old. You have your life ahead of you. You are doing nothing at this point when you should be at a minimum in high school trying to get your degree. I'm now also making that a condition of your bond. You are to get back into high school or get your GED. And I'm going to bring you back in 2 weeks and I want to see what you have done to start that. If you've done nothing, it's not going to go well. Do you understand, Mr. Cuellar?
Yes, sir.
He lives with you.
He actually does. He actually lives with me now, but he just got here like 2 weeks, like maybe a couple weeks ago. So he's been living with his grandparents out of Victoria.
Okay.
He's not even from there.
Is he behaving with you? Okay.
The whole point has been kind of like a problem with him living down there. So that's why I got him and try to get him down.
Has he been having a lot of issues down there?
Not that I know of. I don't know of the issues down there. I'm just becoming aware. You know what I'm saying? We just kind of like connected and trying to make everything right now.
This is not a good way to start through your life. You look high as hell right now, Mr. Cuellar. I mean, I want you to start working on your education, and I'm going to keep you extremely close to me. I'm going to make sure that you do not pick up any new cases, and the system is not going to fail you here. Do you understand? If I have to keep putting you in jail to make sure to get you to understand, we're going to do that. But you will leave here a success. You're not going to leave here worse off than you came. Do you understand? Okay. Would you like me to appoint him a lawyer? Okay, I'll appoint him a lawyer, but I'm going to send him for a drug test. I want to know what, if anything, he's going to test positive for. And we'll have him come right back, and then I'll momentarily have him talk to a lawyer as well, and then we'll discuss the bond conditions as well. If you have any issues with him, just let me know, and then I'll take care of it for you. All you got to tell me is what's going on. He starts acting a fool, tell me, and I'll straighten everything out for you. Okay? Before you leave, I'll give you my card as well so that you can get in contact with us. All right? Okay. Mr. Cuellar, how old are you?
How old am I?
Yeah.
17.
Okay. You've heard every other 17-year-old what I've said to them here.
Sorry.
It applies to you as well. This system will not fail you, and we want to make you leave better than you came here. So you will be expected to fulfill conditions that we put on, and if you don't, we have one place for you. Do you understand?
Yes, sir.
The dope stops today. I will test you 40 days from today. Police, he just tested positive for marijuana or anything else? Cuellar.
Alcohol as well.
Now I'm putting a monitor on you so I know that you're not consuming alcohol.
I don't drink. I just took a shot for my friend's birthday.
Okay. No alcohol.
I don't even like drinking.
Okay. No alcohol. Do you understand? If I find that you're consuming alcohol, if I find that you're consuming illegal drugs, you smoke marijuana, I will put you in jail. I will test you 40 days from today. And I'm not going to take excuses that I was in a car, everybody else was smoking, I went to a party, I don't care. If you put yourself into that situation, only one thing's going to happen. Stay away from it, not until Not while this case is over with, until this case is over with. I'm going to bring you back in 2 weeks and I want to see what you've done to either get back into high school or start working on your GED. That means enrollment. And I will give you a list of places here before you leave so you know where to go to start looking into, to start calling around to get your GED. If you fail to do that, it's not going to go well here. Do you understand?
Sir.
Look on the TV. That's John. He's been appointed to represent you. That is your lawyer. It is your responsibility to stay in touch with him. If he tells me he can't get a hold of you, if you pick up a new case, you start acting a fool in the free world, I will take the free world away from you in a second. All I want you to do is not act like a child. You act like a child, I'll put you over my knee and I'll spank you like a child, but I'll do it with a ton of jail time. Do you understand? The day of you being a child is over. You are now an adult and you will be treated like an adult. If you play stupid games, you win stupid prizes. All I want you to do is leave better than you came here, and I'll do everything in my power to make it happen.
Sir.
Okay. Can you print me out that list form, please? Yes. All right. So I'm going to have you sign a receipt with Victoria. You'll meet with Fleischer for all your conditions, and then you're off on your way. We'll roll your court costs so you won't pay.
Judge, is the reset on the 22nd?
Say it again?
The reset 2 weeks on the 22nd?
Yes, no, 2 weeks from today.
Yeah, 2 weeks from today.
Okay, that's.
How's December 2nd? Just because that's a holiday.
December 2nd-ish.
December 2nd-ish is perfect. Second.
All right, it's yours. Required, yeah. You're going to get tested. Do you understand? Okay.
Mr. Diego, the courts is going to give you some information with my office.
Hold on, John. He's talking to. Okay, go for it, John.
Diego, the courts should give you some information with my office number. When you leave court, call that number immediately.
Sir.
I'll get your information, or if the courts give it to me, and I'll reach out to you. I just don't want you to have to say it, while we're talking on Zoom. Okay?
Yes, sir.
All right, I'll talk to you soon then.
All right.
Thank you, Judge.
Thanks, John.
Good weekend.
So do you know who got land? John?
John Long got
Lamb, yeah. I wonder why I never approached on the bond. Oriana Guevara Aponte.
¿Dónde es usted?
Sí, señor.
Ma'am, you were charged with theft.
La acusa con hurto, robo.
You were facing up to 6 months in jail and/or a $2,000 fine.
De $2,000.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Officers were dispatched to a Walmart in Harris County, Texas, in response to a death. The loss prevention officer told officers that the defendant placed numerous items into Walmart shopping bags that were already in her car. The defendant continued to place additional items into the bags, including a blanket and plug-in sets. The defendant then walked past all points of sale without paying for the items. No prior criminal history, Judge.
¿Cuál es el valor?
The DIMs don't say. I'm checking to see if the offense report is up.
Great to see you. Look.
We do have some discovery, and I'm just seeing if one of them is the offense.
Need a value.
I know. Okay, yes, $218.52.
Ms. Guevara, I'm going to find that there's probable cause to go forward with the case. Tell me, are you a United States citizen?
No.
Are you in this country with or without permission?
Sin permiso.
Con permiso.
With permission.
I don't know whether you do or
No sé
not.
si lo
Quite
tiene o
frankly,
no,
it doesn't matter. The only thing I will tell you is that if you are not, or if there's any problem with your paperwork and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody until this case is over with and then shipped off to immigration and sit there for another 6 to 9 months. If you do not want that to happen, do not violate any of the conditions that we put forth on you now and do not pick up a new case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason whatsoever. Do you understand?
Entendido. Sí, señor. Yes, sir.
If I find that you go to Walmart, I'm going to revoke your bond, put you in jail. You will not get any more PR bonds. Now, you have an attorney. It is your responsibility to stay in touch with Ms. Garcia. She will tell you when you have to come back to court. If she tells me she can't get a hold of you, likewise, we will issue a warrant for your arrest. We will have you sign a reset with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Heed this warning, man. You will not get another one.
Esa advertencia no va a tener otra.
Please. Thank you.
Hacia la izquierda. My competition.
Fight. Fight. Fight.
Judge, the next Spanish speaker is page 6, Jay Alvarado.
Helen Tofila de Alvarado Mejia. You are Helen de Alvarado Mejia.
Yes.
Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Officers were dispatched to a J.C. Penney in Harris County, Texas, in response to a theft. The loss prevention officer told officers that he observed the defendant take various items and walk past all points of sales without paying. The officer observed this on the store surveillance. The total cost of the stolen items was $178, and the items included a smartwatch and skin products. The co-defendant in the case was arrested for possession of a controlled substance out of the same transaction, and she's up in felony courts, and this defendant has no prior criminal history.
Did the other person have a theft case as well? Do you know? Or just a PCS? Because if they also charged the co-defendant with theft, we need to know what the cause number is, because it may
It
transfer.
was just a PCS, Judge.
That's it? Okay. Ms. De Alvarado, I'm going to find that there's probable cause to go forward with the case. Tell me, are you a United States citizen? What happens if you go to jail, man?
Well, I don't want to go to jail.
I know.
Just say.
That's not my question.
Eso no fue mi pregunta.
What happens if you go to jail? I want you to think and I want you to realize the consequence of behavior. So tell me, what happens if you go to jail?
¿Qué pasa si se da caso?
No, pues. Mis hijas deberían apoyo.
But my daughters would
Mi familia.
be without support in my family.
You're not in this country with permission.
No están en país
So
con
if you go to
permiso.
jail and immigration finds you, there will put a detainer on you. And you're going to be in there for about 6 to 9 months. That's what you have waiting for you if you go to jail. Anything more than 4 hours, immigration sweeps it on a daily basis. I'm going to put conditions on you now. If you violate these conditions, I'll put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
The relationship is the co-defendant to this person. Do you know?
It doesn't seem to.
Okay. I'm ordering you not to have any contact with this person. I'm also ordering you not to go back to JCPenney. If you violate these conditions, likewise, you know what's going to happen. You will not get any more warnings from us.
So no contact with co-defendant
Yeah, or going to the JCPenney.
any other.
Yeah, any JCPenney. Tell me, ma'am, what do you do for a living?
Trabajo en remodelación.
I work in remodeling.
Do you have a steady income?
¿Tiene ingresos estables?
No.
No.
Apply for an appointed lawyer.
¿Quiere aplicar por un nuevo edificio?
Sí.
Yes.
Okay, we'll give you an application.
Alguna aplicación.
I need you to fill it out. I need to know everything about you. Do not just leave everything blank. I will send it right back to you. I need to know numbers. I need to know how much money you have coming in a month. I need to know how much money you spend. We'll have you take a seat in the jury box while you do that. Do not leave until you sign our bond conditions. Otherwise, I'll issue one for your arrest as well. And then we'll take a look at the application here shortly. Please, yeah. Anytime someone's not monitored, yeah, please.